Judgment in the matter of Oakwood Solicitors Ltd against Menzies.
Lord Hamlin will explain this judgment.
The Court has long had powers to ensure that solicitors do not claim excessive remuneration for work done by them. These powers are exercised through the Court's taxation, or in modern terminology, assessment, of solicitors' bills of costs. An assessment involves the Court determining whether the costs are reasonably incurred and are reasonable in amount. The right to apply to the Court for assessment of a solicitor's bill of costs is governed by Section 70 of the Solicitors Act 1974. Under the statutory scheme, that right is subject to time limits. Stricter time limits apply if there has been payment of the bill, and in particular, under Section 70, subsection 4, there is no right to an assessment 12 months after payment of the bill. The issue which arises on this appeal is what constitutes payment for these purposes. The appellant contends that, as the High Court held, it requires that the client should have been informed of and have provided agreement to the specific amount in respect of which payment is to be made pursuant to the bill. The Respondent contends that, as the Court of Appeal held, all that is required is an agreement with the client that fees may be deducted from monies held to the client's account and delivery to the client of a bill setting out the amount of the fees. By way of factual background, the appellant, Mr Menzies, who I shall call the client, was involved in a road traffic accident in which he suffered serious injuries. The client instructed the Respondent, Oakwood Solicitors Ltd, who I shall call the solicitors, to pursue a claim for damages for personal injury. They entered into a conditional fee agreement, or CFA, whereby it was agreed that the solicitors would take the balance of its charges from any damages received, subject to a cap of 25%. The client then accepted an offer of £275,000 to settle his claim. Following the settlement, on the 11th July 2019, the solicitors issued a final statute bill to the client, stating its total fees and deducting them from the damages. On the 1st of April 2021, the client applied to the Court for an assessment of the final statute bill. The costs judge decided that payment had occurred when the solicitors initially deducted its fee from the damages, and, because that was over 12 months previously, the claim was time-barred. The High Court allowed an appeal on the basis that there had been no settlement of account, so as to permit the deduction by the solicitors to be treated as payment. The solicitors appealed to the Court of Appeal, which allowed the appeal, and decided that the fact that the client had agreed to the initial CFA meant that no agreement to the amount ultimately deducted by the solicitors or settlement of account was necessary. The client now appeals to the Supreme Court. The Supreme Court unanimously allows the appeal. I give the judgment with which the other justices agree. The meaning of payment needs to be considered in light of its context and the purpose of the statutory provisions. As to the ordinary meaning of payment, the most obvious example of payment of a solicitor's bill is a situation where a bill is rendered and then paid by the client transferring money to the solicitor. By making the transfer, the client is accepting and agreeing to the amount charged in the bill which has been rendered. Payment may also be made by means of an authorised deduction from monies held. Such a payment would only correspond with the most obvious example of payment if there had similarly been agreement as to the amount to be paid in respect of the bill. That would provide a consistent meaning to what is required for payment. As to the statutory context, it is to be noted that on the solicitor's case, payment for the purposes of Section 70 may be made on and simultaneously with delivery of the bill of costs. Payment can thus occur before the client has an opportunity to see, consider, or take advice in relation to the bill of costs. Bearing that in mind, there are a number of considerations which support the client's case. First, Section 70 is concerned with the proper amount to be charged by way of costs, having regard to whether they've been reasonably incurred and are reasonable in amount. That being so, it would be surprising if payment was to occur without there being any opportunity for the client to consider the detail of the bill of costs and to decide whether, and if so, to what extent, it should be paid. Secondly, delivery to the client of a bill complying with the statutory requirements is integral to the statutory scheme. This emphasis on delivery highlights that the detail of the bill delivered and the opportunity for the client to consider that detail is of central importance. Thirdly, Section 70 envisages payment after delivery of the bill of costs, and therefore not by virtue of the delivery of the bill. As to the purpose of the regime, it is apparent that the requirements that bills of costs be delivered, that the bills comply with statutory conditions, and the right to have those bills assessed are concerned with the protection of the interests of the client. Client protection is diminished if payment occurs before there is any opportunity to consider the bill of costs and whether, and if so, to what extent it should be paid. As to the specific purpose of Section 70, subsection 4, the obvious reasons for the stricter regime that applies where the bill has been paid is that payment by a client of a particular bill is taken to represent acceptance and agreement by the client to the sums claimed in that bill. On the solicitor's case, however, payment may occur without there being any such opportunity. Considerations of ordinary meaning, context and purpose therefore favour the client's case. The court then considered the relevant authorities which date from the Solicitors Act 1843, which first introduced the statutory scheme. The court concluded that the authorities show a long-established understanding as to what payment by deduction or retention requires in this context, both generally and with specific reference to Section 70 and its statutory predecessors. The need for a settlement of account has been consistently stated in cases from In re Bignold in 1845 to Harrison and Tew in 1987. This requires an agreement to the sum taken or to be taken by way of payment of the bill of costs. Such an agreement may, in an appropriate case, be inferred from the parties' conduct, and in particular from the client's acceptance of the balance claimed in the delivered bill. The authorities therefore provide strong support for the client's case of the need for an agreement as to the amount to be paid in respect to the bill of costs, and that mere delivery of the bill does not suffice. The court also considered the practical implications of acceptance of the client's case and rejected the solicitor's case that it would have serious practical repercussions for solicitors' practice management in modern conditions. The appeal is accordingly allowed.
The court will now adjourn.